criminal proceeding is concerned, this week involves a module that will equip students with skills required to manage and conduct trial proceedings in the High Court. So previously, we are dealing with Chief Magistrate's Court. So basically, that's why we had to proceed with the charge sheet. But now, the fact that we are going to the High Court, we shall be proceeding by indictment. We shall also see committal proceedings, because in High Court, you first have to do committal proceedings, and these committal proceedings happen when a person is taken to the Chief Magistrate's Court, basically for the purposes of being read the charges under Section 161 of the Chief Magistrate's Courts Act. So students as attorneys will be required to render and prepare legal advisory memoranda, direct the police during investigations, draft relevant trial court documents, prosecute and defend homicide cases, illustrate, exercise the power of the Registrar of the High Court, the DPP, and those of the High Court. So basically here we are dealing with homicides. And when we talk about homicide, we are dealing with those offenses where there is the death of a human being. And one of them is, of course, a murder, which involves the death of a human being. Those are the offenses we call homicides. So we shall be looking at the role of the Registrar of the High Court, included to appoint assessors. Remember, now we're going to be looking at assessors that under the Trial and Indictment Act, the assessors must be there for us to have a trial in the High Court. So we shall look at the powers of the DPP again under Article 122 to withdraw, and also to withdraw and order the police for further investigations. So this module will also encompass unique aspects such as preliminary hearings. So we shall also look at preliminary hearings where, for example, the parties want to agree on the documents, and participation of assessors during the trial. The schools will be imparted to students through advisories and practical demonstrations or role plays. The aims of these workshops are to develop the ability to institute criminal cases before the High Court. We shall basically look at how to institute criminal cases before the High Court, to include committal proceedings, unlike in the Chief Magistrate's Courts. Here in the High Court, we have to first do what we call committal proceedings. Develop the ability to manage the trial processes before the High Court. There must be assessors. Develop the ability to prosecute and defend homicide cases before the High Court. Basically, we shall look at the ingredients of murder, including the death of a human being, causation, and that the participation of the accused. Develop the ability to institute and handle bail applications before the High Court. We see under Article 23(6) and also under Article 28, presumption of innocence, we can proceed and then apply for bail in the High Court. Then identify issues, not overcharging clients, avoiding conflict of interests, and also ensuring that you defend the rights of the person. So learning outcomes: by the end of this first workshop, students should be able to peruse a police file and identify possible offenses disclosed and their ingredients. So we shall also develop on our skills of perusing police files, critically analyze and evaluate evidence assembled in homicide cases. So basically, when we talk about homicide cases, we are dealing with murder, where there is basically the death of a human being. Draft committal documents, we shall look at the summary of the case together with an indictment. Then from there, we shall look at draft the necessary documents for bail applications before the High Court, which shall be the notice of motion supported by an affidavit, and then arrange criminal sessions ready for hearings to commence, where we shall look at appointing of assessors in the High Court. So here we have a police statement by Katono Gossiper, 41 years old. Above are my particulars. I wish to say that in the morning of 10 towards 2 a.m., I and my husband, Gubere Wada, we are woken up by some noise outside the house. We failed to sleep, so my husband decided to tiptoe and move out of the house to check on the chicken, which were making noise. When my husband went out, some people had invaded our home. They locked me inside the house using a bolt, and they then set up upon my husband, hacking him with machetes and other objects. Then set upon my husband, hacking him with machetes and other objects. As he was being attacked, he kept shouting and also mentioning the names of his assailants. My husband mentioned some names. He also mentioned bad news, and another person. We do not have electricity in our home. I was making an alarm. I peeped through the keyhole, and I was able to see a certain man in our compound with the aid of some moonlight. The man had no hair on his head. I was later able to identify him as the police, and I was told by the police after some procedures that he was Wagaba. As I was still inside the house, I ran to another part of the house and peeped through the window. I could see the scene very well through the window. Although I could not see everyone, I kept watching and listening to what they were saying, and I was able to recognize the voice of the man I know as Bad News. I have known him since childhood. He operates a boda motorcycle within our local trading center. Is a very talkative person, and his voice is well known to me. So basically, you can see here we have identifications, the law governing identification. Basically, you have to look at the source of light, the distance, as well as the distance between the person identifying as well as the accused. So when they left, I gathered some courage and went outside to look for my husband. I found my husband lying in a pool of blood. My neighbor Bogere was at his time in compound holding a panga and a spear. He told me that he had my husband calling for help, and he immediately came running for rescue to meet the assailants freeing. When I looked around, I picked an ID of a man called Wagaba from my compound. I gave it to the police in the morning. That same morning, I rushed my husband to Ginger Hospital, where he was admitted in a very critical condition. Although he was still unwell, we could no longer manage the mounting hospital bills. He was briefly discharged in January 2025, but he was still unable to speak. He was readmitted in hospital again in February to police after the assault. Then a letter to the police where I reported the incident. I have never seen Bulgaria again since that night of the attack. This is all I can state for now. So basically, we can see here the person was, although he was still unwell, we could no longer manage the mounting hospital bills. He was briefly discharged in January 25, but he was still unable to speak. He was admitted in hospital again in February. He died on the 1st. So we can see that the person here, there was death. So we shall be dealing with murder as an offense. And let me just go and read the statement of the suspect's parent statement. That above my particulars, I know that deceased as my friend. There is no way that I can try to take the way of life of the deceased. I'm just a victim of circumstances. I was not even in the village that night. I had gone to do some business in Masaka with my friend, and who stays in Kampala. I have my own woman. My wife knows that I slept at home. I am being framed by my enemies. So basically, the suspect is bringing up about the defense of alibi. The defense of alibi was discussed in Uganda versus Akgodba. So it basically still remains the role of the prosecution to put the accused on the scene of crime. Then suspect's parent statement that the above, my particulars did not know anything about the deceased. T is a lie. I'm blackmailed into accepting something that I did not do. For me, I know Ginger, but I live in Kampala. I know nothing. This is all I can state. Statement of the investigating officer. The above particulars are mine. I'm the investigating officer in this case. I wish to state that in the morning of 11th October 2024 at about 9 hours, my OC CIDD allocated me case reference that had earlier been reported. This was being reported by a complainant called Katono Gossiper against some people who attached their home at night. Her husband fell victim and was badly injured. The victim was in critical care for some time. He was in and out of hospital. Musere, who had reported to Masaka town, the rest are still at large. I had issues with PF in the victim while he was still alive, but the victim eventually passed away on this one. Immediately failed PF4 and booked out the Ginger mortuary in the company. So basically, you can see here we have enough evidence proof murder. We even have the examination on arrested person. We also have examination by medical officer, which is also going to help us. We also have a request for the postmortem report. So this one is all going to help us to do what? To prove the offense of murder. So assume that you are the resident chief assistant of Ginger, and above to you police peruse the case file and do the following: identify the offenses. So basically we are going to be charging the person of murder. The evidence of murder was stated in the case of Uganda versus Wera Senga to include the death of a person, the causation, as well as the participation of the accused. So that's basically what shall be evaluating. And evaluate the evidence. We can see from the very many statements proving that there was death, from the statement of the wife, the investigating officer, causation, the person was found lying in blood, and thereafter he was readmitted in the hospital and pronounced dead. Then participation of the accused, that's where the most of the discussion is going to be, because this person brings in the defense of alibi. But however, it's a defense, it's a role of the prosecution. Remember, section 101 of the Evidence Act, the burden of proof is always on prosecution, and the standard of proof is beyond reasonable doubt. So we must press the accused person on the scene of crime. So assuming that the evidence is sufficient to sustain the charges, draft the documents necessary for purpose of trial before the High Court. So we shall draft a summary of the case for basically committal proceedings before the Chief Magistrate's Court. Then we shall also draft an indictment. For basically for those documents. So assuming you are in the Chief Magistrate's Court and the Chief Magistrate Attorney informs the court that the investigation inquiries in the matter are complete and that they are ready to move forward with the case, by way of prayer, have the accused person committed to the court of trial. So basically, if the Magistrate's Court under section 161, he can proceed to commit this person to the High Court. You get basically read the offences and then say that we as the Chief Magistrate's Court, we have no powers to try this court, therefore we hereby commit you for trial of the High Court. Assume that you are an advocate in private practice and have been approached by the relatives of the accused person who is currently remanded at Kirinya government prison. Advise them on the remedy available to him in the circumstances. You have to proceed and apply for bail under Article 23(6) of the Constitution, as well as Article 28, presumption of innocence. The documents are notes of motion supported by an affidavit in support. Assume you are the Chief Attorney and you have been served the documents envisaged above, draft a response. We shall have to draft an affidavit in reply. Then assume that you are the Deputy Registrar of the High Court and you have been directed to arrange criminal sessions outlining the practical steps. The practical steps include appointing assessors. You have to make sure you appoint assessors, allocate the files to the judge, serve hearing notices to the parties, cause the list, and then after that, the trial will be had. Then assume that you are the Deputy Registrar of the High Court and you have been directed to arrange a criminal session, outline and practical steps you will take, ESCO issues, avoid conflict of interests, like we saw in the case of Ojangare, that you must not represent a client where there is a conflict of interest. Don't overcharge your client. And then secondly, make sure that you do proper due diligence, not properly defending your client's case, as we can see in the case of Kapchorwa. The case of Chimongeza versus Kapchorwa Referral Hospital. Basically, that would be for workshop 1. That's basically what you're supposed to be looking at. So as far as workshop 2 is concerned, the aim of these workshops are to elaborate the executed duties of the DPP under Article 120 of the Constitution, to investigate, to withdraw administrative powers, including granting and conditional release, develop the ability to conduct a preliminary hearing where you want to have accepted a document, you conduct a preliminary hearing, develop the ability to prosecute and defend homicide cases. Here we have murder. Develop the ability to institute and handle bail applications before the High Court. Basically, you apply by notice of motion supported by an affidavit. You have to prove exceptional circumstances, being an extraordinary age, having a disease. You must have fixed place of abode, and also substantial witnesses. Then identify ESCO issues. Then learning outcomes says the powers of the DPP over cases before the High Court, negotiate and conclude pre-bargaining agreements. We shall look at pre-bargaining agreements and the pre-bargaining rules, constitute the High Court and manage the trial processes, conduct preliminary hearings in the High Court, read evidence and cross-examine witnesses produced before the court, and identify ESCO issues. Workshop 2 tasks. We are using the facts of workshop 1. One, assume that you are State Attorney, the office of the DPP, and the accused counsel informs you that his client is willing to enter a compromise without going through a full trial, demonstrate the practical steps. So basically here you have to initiate negotiations with the state, and you sign what we call a pre-bargaining agreement. After that, it's governed by the pre-bargaining rules. Assume the position of a judge of the High Court constitutes the court in a criminal session by way of demonstration, proceed take and record the plea of not guilty and bring on board the assessors to preparation to commence the hearing. So basically here what we are looking at, one is the trial. The process of pre-taking was discussed in the case of Adan versus R. You must inform the accused person the offense is being charged of, the ingredients, the sections, and the facts, and he must plead to each and every offense. Ingredient. Once he has pleaded guilty, Then you have to direct the assessors, the burden of proof, the standard of proof, and then invite them to hear the hearings, and after that you want them to make an opinion. 3. Assume you're a judge of the High Court and during a preliminary hearing you have been informed by the defense attorney that the client does not intend to object to the PF 24 being tendered in court as prosecution. In properly considered court to demonstrate the process by which you would ensure that the said PF is received. So basically here you do a preliminary hearing and then you admit this document. So once this document is admitted in the preliminary hearing, it basically means that it's not going to be objected to. So in this preliminary hearing, it's like the courtroom conference, but this courtroom conference is more in civil litigation. Here we're dealing in criminal proceedings. Assume that you are before the high session as state attorney and defense proceed to cross-examine the complainant. So basically when you talk about cross-examining, you have to understand cross-examining, you are asking leading questions. So you have to understand the difference between examining in chief and cross-examining and re-examination. Examining in chief, you are basically asking open-ended questions: what, where, and why. Whereas in examination in chief, you're asking open-ended questions: what, where, why, and how. Then whereas in in cross-examination, you are asking leading questions. So you basically give the answer to the person and you want him to confirm by either a yes or a no. Then from there, we looked at leading the evidence of the witnesses. Then after that, assume the role proof. After reading the evidence of the witness number 4, you come to the conclusion that it is prejudicial to continue with the proceedings. Proceed to prepare an opinion to the DPP to terminate proceedings. We can see under Article 120 the DPP has powers to terminate proceedings where there is no adequate evidence or where it's in the public interest by filing what we call a notice to prosecute, and basically you terminate the proceedings. Identify ESCO issues, a very conflict of interest, doing proper due diligence, ensuring that you don't overcharge clients, appearing for your clients. Basically, those are some things we shall be dealing with. So preparation for the workshop. The laws we are supposed to use, one, the Constitution, of course, the Constitutional Bill guidelines. Then we have the case of Seif Muhammad versus Uganda. This was the Lucas Classics case on murder. Remember this case, it happened on Pine, whereby this person was demanding some certain amount of money. Then after that, I think they called him to pay the balance for long. They started torturing him. Even the lawyer came on the scene of crime. They beat the lawyer, and then after the person was pronounced dead, so they charged him and 7 others of murder, and he has since been convicted and is serving, I think, 45 years in prison. So Seif Muhammad and 7 others is also on murder. Then the other case here we can talk about is of course we have Musingo's Apple versus Uganda on pre-bargaining, that's binding to the parties. Foundations for Human Rights Initiative versus Anthony General on application for bail. Anthony General versus Joseph Tumushabe also on bail. Then Dr. Chinji versus Uganda on murder also. So basically that's what we shall be looking at, and that's what we expect to look at criminal proceedings in this week. So if you have understood what we did in term 1, then this one is going to become very easy. So please make sure that you like, subscribe, share, and comment, and turn on that notification button so as you don't miss any video, because we bring all the analysis as they happen live up to the very end of this so please, we wish a blessed week. Never lose hope. We believe in you here from the Pass the Bat team. But in case you want to join a mastermind group, we'll have a mastermind group where students pay a master subscription fee, so you can pay and be a part of that discussion. Please have a blessed week.